Don't worry, your camera will be off. Okay, so good evening, everyone. So we'll be starting with a new topic that will be law of torts. Damini, you want to ask the question? You can give it for everyone so that everyone can see the question. Damini. Mere silence means simply keeping quiet. So, do you remember the first example where the person who is auctioning the horse didn't say a word because the person who won the auction never asked anything? So he kept silence. So keeping silence is not fraud, but keeping silence in the time of hiding a fact, that is fraud. So if you keep silence, nobody's asking, don't tell. That won't be fraud. That is mere silence is not fraud. It is fraud. What is fraud? Yes, Zaid, I didn't get it. So that is second one. That is the second one. But mere silence, simply keeping silent is not fraud. But under certain circumstances, it may be fraud. Free speech is if you can say anything against anyone, unless and until it is not hurting anyone's legal right. Hate speech is a speech where a section of the public is enticed to hate. That is hate speech. Yes, if I say certain things about certain community, certain group of people, etc., and that they incite to be hated upon, then that is nothing but hate speech. But why are you asking? I didn't get it. Public order is the order for the public, like the laws passed by the public, like say alcohol is banned in Bihar. So that is a public order that is meant for the public. Okay. What is meant by pledges? Okay, Afsar, let me just come to you. Prince Rajput, you want to ask certain things, ask for everyone so that everyone gets to know the answer. Okay, so Prince Rajput asked a question which says that what is meant by pledges? Pledges means, like I have told you about pledge. When you give your product for security of a loan, you took a loan, you gave a product. So once you return the loan, you'll get back your product. That is pledge. So what it mean by public order? Is it subjective in some cases? Yes, it depends entirely on the government. What portion of the public should be affected or is problematic or needs to be corrected. Right. So are legal judgments of Supreme Court. Yes, it's important. How can you get a list? Just go to the internet, Google top cases of 2020 and then search in the site of live law. Search in the site of live law, you'll get that bar bench site anywhere. Live law is they give top 25 website, etc. Top 25 cases, something like that. Live law gave 60 cases. Let me see. Yeah, live law this time has published 60 landmark judgment, but bar and bench has 25. No, that is not there. So let it go to January, February. You'll have a list of 25, 30 cases. Okay. So let's start with law of torts now. Vibhu, so on your aspiration account, you are provided with all the legal development each month. So we can also collect it from there as well. Any which way, let's start now. Okay. So the only thing that I can see is Saurabh writing something very seriously. Okay, so now he's not serious. Okay, so let's start with law of torts. Now, before we start with law of torts, I wish to give you a small background of what is law of torts, etc., and how it's important in India. Fine. So, law of torts kya kehta hai? Like, for example, we studied some laws before. We studied Contract Act. So, Contract Act, if I ask you which year it was made, you can easily say 1872. What section number 10 is, what section, that section. We can already see the book and we can answer. But law of torts is a different structure. It's a only law in India which is not written. It is not codified. Fine, rest all the laws that are there in India are codified laws, meaning thereby it's a written law, and law of torts is not a written law. So there is nothing fixed, and it all depends on the last cases that were decided. Fine. इंडिया में थोड़ा दिक्कत है लॉ ऑफ टॉर्ट्स का. कैसे some examples देखते हैं. Then we'll see how law of torts is not that successful in India. Okay, so we all have played some of the other games in our convention. No, not convention. Previously decided cases. Precedent कहते हैं उसको. No conventions. I'll give you a small definition as well. First, let me just give you some examples of how, what is torts, etc. So we all have played some of the other games in our neighborhood, in our backyard. Like for example, I used to play cricket on my terrace when I was like in my school. So the ball used to go in my neighbor's field. We used to go to our neighbor's house, take the ball, and come back without even disturbing the neighbors. We used to do that because they know me and I know them. So we used to go there, pick our ball, take our balls, and then we used to come back. Now, as per law of torts, that is a wrong act, and that has to be compensated. Because as per torts law, you cannot enter anyone's property without their permission. But we do. Okay? Under law of torts, it's not allowed. But under normal Indian laws, under normal Indian situation that we are in, we don't ask permission for that. Or some other examples, like my neighbor has a mango tree. Now the mango tree is so huge that some of the branches are coming in my area, in my house, in my property. What can I do? Yes, these laws are enforceable. So tell me, what can I do? If the trees, some branches are coming to my area, what can we do? We can eat the mangoes. First, we can eat the mangoes, but we can eat means not the trees, but yeah, the mangoes we can. What else we can do? Indian situation में क्या होगा? Mangoes आएगा, हम खा सकते हैं. ठीक है? And we are good neighbors, so we'll pluck all the mangoes. We'll keep some for ourselves, and some will return it to them. ठीक है? But okay, so we can cut the branches as well. We can tell the neighbors. Anything else? Anything else? So that is the Indian case. Now, what is law of tort says? Law of tort says that that mango tree belongs to my neighbor. So if the mango tree has entered my property without my permission, so in a way, the owner has entered my property. So what you can do, you can pluck all the mangoes, cut the trees, everything, cut the branches that are there in your area, and also file a case of trespass against the neighbor. What happens in India? We can file a case of torts, but we can file a case of torts against them, but we don't file it. That is the Indian situation. Anushka, trespass. Trespass is entering into somebody else's property without permission. So that tree belonged to my neighbor. They entered my property without my permission. So that is trespass. फाइन पर इंडिया में क्या होता है कभी सोच भी नहीं सकता कोई केस करेगा फाइन सो टॉर्ट्स केस में क्या होता है if you file a torts case you will never get punishment you will never see the other person against whom you have complained going to jail. What happens in torts? You get compensation. We call it damages. You need to compensate the person because torts is a civil wrong. Right. I'll come to that. Unliquidated and liquidated. I'll come to that. Because torts is called as a civil wrong. Like for example, Mr. A slapped Mr. B. Mr. A slapped Mr. B. What are the options available with Mr. B? Legal options. Tell me, what are the options available to Mr. B? file a suit. He can file an FIR as well. Zaid, I told you, right? Legal solutions. And Shan, applying of extra brains is prohibited in my class. Okay. So he has two options. Either file an FIR and see him go behind jail, or file a torts case and get compensation. इंडिया में क्या होता है? FIR करना है मुझे, किसी को compensation नहीं चाहिए होता है. What we want the person whom we don't like to go behind jail. We don't want compensation. इंडिया में compensation कोई लेता ही नहीं है. What they want, even if it's a 2-day jail, send that person behind jail. We don't want compensation. And that is why law of torts is not a success in India. So Shresh, you don't need sections for that. We have topics for this. Okay, we have topics for this, and under the topic there are decided cases by the Britishers or by Indian court, sorry. And based on those cases, you can file a case. I'll tell you, don't worry. See, for example, Mr. A and Mr. B are, say, 12th going kids, and they had a fight. Mr. A badly beat up Mr. B. Mr. B was badly beaten up by Mr. A. Fine. Yes, sort of. It's only for compensation. So Mr. A badly beats up Mr. B. Now Mr. B has two options: file an FIR or get compensation. As per general public, general students of Patna, what we say that let's settle it in the center, in the children park or in the main field. But imagine करो कि तुमने compensation का case file कर दिया and you demanded 5 lakhs of compensation. So the court will give you some compensation because the other person has done wrong on you. Imagine your college will be so easy, you will have so much of money. But what we do, we fight or we file a criminal case. So India में compensation किसी को चाहिए ही नहीं. What they want is jail. And therefore there are so many difficulties in law of torts that it is not a hit thing in India. People don't follow torts. Like for example, you are all well dressed, completely well dressed, and you are going to a marriage, say a marriage meeting, not a marriage meeting, but you're going for a marriage party. You're all dressed up, everything. Fine. Now another person comes with a bucket of water and splashed against you. You're all dripping wet. What can you do? That guy who has splashed water on you shouts happy Holi and then goes away. India में क्या होगा? कुछ नहीं. Holi है. But under law of torts, that's a fit case for compensation. But will you file cases for that? We don't file it. Can we file a case? Yes, we can. But we won't be able to do that. So that's why law of torts is not a success in India. Now, we have given you some enough cases for yours. Tort is available. I'll come to that, Suresh. So tort is all kinds of civil wrongs in the society. Every wrong that you do is a civil wrong because you have done bad to the society. So even murder is a societal wrong. It's a bad thing to the society. And torts is available, but nobody files a case under torts because there's a fixed provision for criminal law, and that is more useful in India. Therefore, if you go to UK and London, they have torts cases for everything. Fine. So let's start with, now that we start with law of torts. First slide. So what is tort? The tort is derived from the Latin word tortum. It means cropped, twisted, or a wrongful act. It is a civil wrong which is redressable by an action for unliquidated damages. Okay, let's break it and then read it. So tort is being derived from the word tortum, which says cropped, twisted, or wrongful act. It's called as tort. Okay, read the point carefully. T-O-R-T, tort. It is a civil wrong which is redressable. How can you file a civil wrong? And what can you file? You can file a civil wrong for unliquidated damages. Now, damages are two types: liquidated and unliquidated. Liquidated means fixed है. Unliquidated means it can be anything. Unliquidated, fixed नहीं है. So, in the similar set of cases, it depends on the court. So, court can grant you different compensation. Fine. So, that is unliquidated damages. Fine. The next thing that is written there is that how it's different from crime. So, before going to the 3 points that you can see before you, remember my 1 point for your CLAT preparation. Let's take an example, say defamation. So defamation is there in IPC as well, and as well as in under law of torts as well. How will you recognize whether the question that is being asked to you is from IPC or is from torts? The only thing that can differentiate is if the question talks about compensation, then it is torts. And if it talks about punishment, then it is IPC. Okay? If it talks about compensation, it's torts. And if it talks about punishment, then it is IPC. So what are we reading here? We are reading law of torts, T-O-R-T-S. But if you see the definition, it says tort, T-O-R-T. There is no T-O-R-T-S. Fine. So there is a difference between tort and torts. There's a difference between tort and law of torts. Difference hai. So what is that difference? So tort is all kind of civil wrongs. Tort is all kinds of civil wrongs. And if those civil wrongs are recognized by the courts of India, by the law of the land, then that becomes torts, T-O-R-T-S. So what are we reading? We'll be reading law of torts, T-O-R-T-S, and not tort, T-O-R-T नहीं पढ़ेंगे. We'll study law of torts. ठीक है? अब example देते हैं इसका कैसे इसका meaning होता है. 25-30 years before, मेडिकल नेग्लिजेंस, जब डॉक्टर्स गलत ऑपरेशन कर देते हैं तो उनको कॉम्पनसेशन देना पड़ता है. So the medical negligence was not a term under law of torts. So medical negligence at that time, 25 years before, was tort, T-O-R-T. But since the court recognized medical negligence, therefore it became law of torts, T-O-R-T-S. So all kinds of civil wrongs which have been recognized are called as law of torts. There may be some few civil wrong that comes up after say 10 years, 15 years, then that will be again called as torts. Till today, there are few topics that are recognized, and rest every other civil wrong is law of tort only. right? Okay. So, is it clear till here? Okay. I assume it's clear. So now we'll see what are the important points of torts. The important points of torts, and then the important point defenses of torts. We'll see to it now. So important of torts. First point. If you are essentials of torts, first point. There must be some act or omission on the part of person performance of legal duties. So इतना बड़ा definition याद करने की जरूरत नहीं है. First point you should remember like this, that there should be infringement of your legal rights. There should be some infringement of your legal right, or it may be called as positive wrongful act as well. Like you enter somebody else's land to save him from fire. That's also positive wrongful act. It's a wrongful act because you haven't sought permission to enter. So point number 1, just forget it. Write point number 3 first, that some legal rights must have infringed. Some legal rights must have been infringed. It may be also a positive wrongful act, like entering somebody else's land for saving him from fire. Like a person is stuck in fire, shouting for help. You entered the property and saved him. Fine. So it's a wrongful act, but it's a positive wrongful act because you have entered without permission of somebody to save a human. And that is positive wrongful act. We'll study more on this. Just write down the points. So the first point you'll write is that some legal rights must have been infringed. Fine. Leave point number 4. Point number 4 is big. I'll explain in the last. Come to point number 5. It says motive or intention is irrelevant in law of torts. Motive or intention is irrelevant in law of torts. Motive or intention is irrelevant in law of torts. Meaning thereby, for example, I'm trekking somewhere. I went on a trek into the hills. I'm descending, I'm coming down. And then I entered somebody else's property unknowingly. I was not aware that it's Mr. A's house. Have I done a torts? Yes, no. Have I infringed the right of somebody? Yes. Yes, I have entered somebody else's land. I'm not allowed to enter anybody's land. So I have entered without intention, without motive. Still, it will be a torts case. Why? Because in torts, intention or your motive is not important. Like two friends are very good friends. One of them comes and push him from behind, and the first friend fell down and hurt himself. Is it a torts case? Is it a torts case? Yes. Even though they are good of friends, they have been doing this for 20 years, whatever be the matter, but it is infringement of your right. So motive or intention does not come into play under law of torts. If you have done it, even though with good intention, that is also a law of torts case. So you don't have to see whether he has done it in a positive sense or in a negative sense. He has done it, then he is responsible. Okay. Next point is that there is no defense of minority. So it says that anyone can file a case and you can file a case against anyone. So anyone can sue. So even though a 5-year-old boy did something, then we can file a case against that person as well. There is no problem in that. You can file a case against that. There is no age cap under law of torts. Everyone and anyone can sue each other. Fine. Now come to point number 4 that I told you that we'll do it in later. There are two legal maxims that are there in torts initially. It's called as injuria sine damno. What against unborn child, Vibhu? Can you be a bit elaborate on that? Defense of minority. Defense of minority comes to everyone who is born, right? If the person is not born, defense of minority won't come into picture. Fine. So there are two legal maxims that we need to see. Right. Valid question. If someone refuses to pay compensation, okay, then under law of torts, there is no other way out. You have to refer it to court and criminal laws, and then you have to go to jail. This is why torts is not that active in India, but in UK you have to do it. They'll cut your all facilities and etc. till you pay. ठीक है इंडिया में कुछ नहीं होता. That's why इंडिया में torts बहुत rare है. मतलब like it's very rare. Like for example, in my 8 years of practice and 5 years of being a law student, there was hardly any case. Right, but if had it been a strong law, like say under UK, they don't have to go to criminal laws. They don't have to. Torts law suffices, and if you don't pay compensation, because every facility is linked with the government plan there, so everything of that sort is stopped. So ultimately, the thing that is stopped, with that money, the compensation is paid. So it's a very simple thing there, but here in India, it's not followed. Okay, so there are two legal maxims that we need to study. Those are injuria sine damno and damnum sine injuria. Fine. Injuria sine damno and damno sine injuria. So this word damno, इसमें दो तीन वर्ड आ सकता है. damnum भी आ सकता है, damno भी हो सकता है. दोनों सही है. Sir, can court will give the order to sell someone's property if he or she refuses to do so? Refuses to, the person cannot refuse. He has to pay compensation. There is no refusal. Khushi asked me a question. I am from which NLU? You all prepare properly. I'll tell you which NLU. But if you can go through the social media, it's everywhere written. Okay, so I'll tell you, Khushi. Don't worry. Okay. So there are two legal maxims that we need to see. Injuria sine damnum and damnum sine injuria. अब सबको word divide करने पड़ते हैं. Injuria means a legal injury. Injuria means a legal injury. Damno means damages. So it says that there was a legal injury, but no damages. And the second one says there was damage, but there was no legal injury. Example देखते हैं. There was a person, Mr. A, who was going to vote. An old lady comes with a stick and says that if you go to vote, I'll beat you. That young chap returned to his home and sat there. Mr. A, the young person, wanted to vote for Mr. B. He could not vote because the old lady said that if you go out, he'll beat you. She'll beat you. But ultimately, Mr. B won the election. The candidate to whom Mr. A wanted to vote, he won the election. So this is a fact. Tell me which principle is applicable. First one or second one? First one. It says that there's a legal injury. Legal injury of what? My vote, I could not vote. So that's a legal injury. Damage, there was no damage because I wanted the candidate to win and that candidate won the elections. Fine. So that is a fit case for law of torts. That you have a legal injury does not depend whether you suffer any damage or not. What is important is legal injury. Now, second case talks about, second principle, damno sine injuria. That there was a damage, but there is no legal injury. Fine. Give you one example. There was an old school, which was one of the best school in the city. Now, a new school opened just in front of the old school, and it was charging half the fees that the old school was charging. So maximum children left the old school and took admission in the new school. Also, the new school started paying double the salary to the teachers. And therefore, most of the teachers also left the old school and came to the new school. So tell me which principles should we apply? First one or second one? Second one. Why? Because there was a damage, but there was no legal injury. Because I have a right to open my school. If somebody leaves your school and comes to my school, that's not a legal injury. But yes, damage of financial damage, yes. Can I file a case of law of torts against that? Answer is no. Okay, somebody is trying to enter. Okay, so the first example that we did, that voting was stopped by an old lady, that is called as Ashby versus White. The case name is Ashby versus White. And the second case that we talked about, the school thing, it's called as Gloucester Grammar School case. The spelling of Gloucester is not correct. Okay, yes, for this case name, it's important. Few case names are important for your legal knowledge as well. So it's called as Gloucester and Grammar School case. And नहीं है, Gloucester Grammar School case है. Gloucester का spelling GLOUCI होगा, Gloucesters. तो U missing है उसमें, but spelling of the name पे आपको marks नहीं मिलेंगे. So just remember Gloucester Grammar School case, that's not a problem. But Ashby versus White, वो याद रखेगा. Okay. Okay, so I was not saying anything. So I was giving you time to write. Once you're written, we'll go to the next one. Okay. So we'll go move to the next topic, that is called as general defenses. Okay. So whenever a torts case is filed, you have some defenses to show that how you are not involved or how it was not your fault. Those defenses are called as general defenses, and they are 8 in number. We'll do one by one all the 8. So what are the 8? Voluntary non-fit injuria, plaintiff the wrongdoer, inevitable accident, act of God, private defense, mistake, necessity, and statutory authority. Okay? Please read and learn all the 8. The meaning of all the 8 should be there in your mind, on your fingertips. All your torts cases will be solved on these 8 defenses. बहुत important है ये. ठीक है? So we'll start with the first one, that is voluntary non-fit injuria. Fine. So voluntary non-fit injuria is also called as VNFI. Shortcut है VNFI. Fine, VNFI. So let's break the words and then read it. So voluntary non-fit injuria. Voluntary means voluntarily, खुद से, your consent. Non-fit injuria. Injuria, we have just studied the word legal injury. Okay, legal injury. So it says that if you voluntarily consents to the risk, then there is no legal right infringement. Fine. So if you voluntarily consented to the risk, to the known risk, then in that case, you will never get any compensation. Okay, that's not a legal right infringement. Some example. I went to watch a cricket match. Known risk, बता रहा हूं. I went to watch a cricket match. So what are the risks in watching a cricket match? That a person may hit a six and that the ball may land on me and I may get hurt. But you have consented to the risk. So if any sports person hits a six and that lands on your head, and you are injured, then you cannot claim compensation. Why? Because you have consented to the risk. What an unknown risk. The roof of the stadium falls and you are injured. Can you claim compensation from them? Answer is yes. Answer is yes. Why? Because you entered the stadium to watch the cricket match and all the risk involved with the cricket match. You never entered the stadium so that the roof will fall. That is an unknown risk. And for all unknown risks, you will get compensation. But all the known risk, you will not get compensation because it was your voluntary act. It was your own self act. Right? Siraj hit Manasa head. No, he cannot. That's a compensation. That's a clause that we all sign. The ball hit me outside the stadium. Okay. So I entered the stadium. I cannot take for work compensation. What if my house is outside the stadium? I'm sitting in my garden. Somebody hits a six that lands on my head and I am injured. Can I claim for compensation? Answer is yes. Because you have not consented to the any risk of cricket. You have your own house. You have not even entered the stadium. So you have not consented to the risk. And therefore, you can always claim compensation. Fine. Okay, one more example. So I'm a news reporter. I report news from the cricket stadium or from the sports arena, wherein the person who was the brightest of the day, I take interview of that person. So there was a cricket match going on, crowd fight. What about crowd fight, Sahil? Crowd fight in the stadium. So, how can you file a case against the sports person or the stadium authorities? You can't. You can't file a case against the sports person nor against the stadium owners. So you need to find out people who have injured you and you can file a case against them. No, but Shreyash, if like say five people are fighting and they also injured me, I can file a private case against all the five that they injured me. There's a word called as joint tortfeasor that I'll teach you in the later classes, which says that two or more people can together do a tort. That is joint tortfeasor. We'll tell you in the later class, later part of the class. Okay. So where were we? I was giving an example wherein I am a news reporter and I covered a cricket match. Mr. A was declared the man of the match for that particular cricket match, and he was also given a bike as a trophy. Fine. Harshita, an example is there in the outline of the book, building new by clearing up cost to the. Okay, so yes, Harshita, next, what happened up thereafter? So depend on what time of the night. There's a time limit in India. So if it goes beyond that time limit, then they have to pay compensation. And if it's within that time period, there is no compensation. Okay, so I'm going to take an interview of the man of the match. He has just won a bike, but his bike was being ridden by so like Mr. B and Mr. C were riding the bike. So I went to Mr. A to take his interview. While I'm taking the interview, Mr. B, who was riding Mr. A's bike, hit me and I'm injured. Fine. Can I file a case against Mr. B for compensation? But it's inside the stadium. The answer is, so what risk did I cover? I covered the risk. I stopped for the entire match to get over, and then I entered the stadium. So the risk was nothing. So if I get injured, can I claim compensation from the bike rider? Yes. See, Harshita, in India, the buildings are made for residential and commercial purposes, and according to the areas are demarcated. So if it's a commercial place, no residential things are entertained that much. The person who injured you. Fine. Okay, a few more examples. So I'll request everyone who is asking me a direct question, please make it public to everyone so that everyone will get to know what I'm speaking. Fine. So the question was raised that compensation will be given by whom? Bike rider or bike owner? So the answer is, though the person who hits him will pay the compensation. How do you put it off the direct message option? It's not, I don't know, I'm not that technically. Not about in possession. The person who hit it, let's keep it simple. The person who hit it, the person who infringed somebody else's right is responsible. Okay, Sahil, I'll do that. Okay. Some more examples देखते हैं पहले VNFI का. So what did we understand from VNFI? That you have voluntarily consented to the risk, you will not get compensation. But you have not voluntarily consented to some of the risk, then you will get compensation for that kind of a risk, right? Okay. No. Yeah. A few examples. Listen to me carefully. So I was standing on the edge of the road and the park. So you can say I'm in the middle of both the road as well as the park. I saw an over speeding car coming towards the park where some children were playing. I saw a car coming with a high speed towards the children who were playing in the park. If I and I realized that if I don't intervene, the cars will hit the children. Fine. So I jumped and somehow saved the children. And in the process, I injured myself. Tell me, will I get compensation? Yes, no. So, Khushi, you said yes. Why yes? Shresh, you said yes. Vibhu, you said yes. Why? The answer is that if you take a voluntary risk on your own, then you get zero compensation, right? And rescue cases, I know, but I know you all were referring to rescue cases. Shan, I said no direct messages. So I know you are referring to rescue cases, but I was on the point that I have told you so many times that we are not going to use our brains. So I thought you all have followed. Any which way, that's a nice thing. That most of you have followed. That's okay. Fine. So the answer is in cases of rescue where you save someone, where you save someone, even though you have taken the risk, then you will get compensation. If you have saved someone in taking a voluntary risk, then you get compensation. That is only in the cases of rescue cases. That if you are trying to save someone, you're trying to rescue someone, and then if you rescue someone on your own risk, then you'll get compensation. That's an exceptional situation under VNFI. No, it's not like preventing a bigger damage. It's not like that. Okay. So now one more example, and then we'll stop this VNFI topic. For example, I am a coast guard. My work is to save people from drowning. I saw a person drowning and I saved him. And in the process, I got injured. Can I get compensation? Yes, no. So answer is no. Why? Because people who are assigned to a task, they cannot complain for rescue cases. Their work is to rescue. Okay, so they have voluntarily taken the risk of rescuing people. So they cannot claim compensation for that purpose. any example that we studied, what examples did we study? We have studied first part that you have not taken the risk. If you suffer a legal injury, you'll get compensation. Second type of rescue cases that we studied, that you have taken a risk to save someone, then you'll get compensation. Third example in that we have to see that my work was to save people. So while taking up that job, I have voluntarily taken that risk. And if I save people in that case, then it won't be, then I will never get compensation because I have voluntarily consented to the risk. Fine. Shreyas has a question. If the Coast Guard is off duty on that day and then he says, yes, yes. So when he's off duty, he's not on duty, right? So he's a normal citizen at that time. Then he can. Okay, so this is the first defense that we have done. We go to the second one. Okay, so you were referring to the important judgments of Supreme Court. So today there's an article published in Hindustan Times, which talks about all the key Supreme Court judgments that have been there in 2020. It gives a list of some 10, 15 cases. You can collect that. There's a Hindustan Times article for today. Fine, so there are Hindustan Times articles. You can collect it from there over the online. It's 26th December at 5 p.m. Okay. Now, sir, can you put that on the group? See that I received on the phone. Now I have to put the group. Okay, I'll try doing it. By the end of the class, I'll send it. Which group, Anushka, by the way? Are you talking about Telegram group? Acha, Telegram group 535. Okay, so I got Telegram. I rarely open Telegram. Let me see. So 535 is this batch, right? So I have posted it on 535 and also on. So somebody has already posted on 540 group. Right now. Harshita Raj. Thank you, Harshita Raj. There's a group 230 as well. No, 530. 530 posted. Okay, second point. Plaintiff is the wrongdoer. So who is the plaintiff? Plaintiff is the person who files a case. Who files a case under law of torts is called as plaintiff. So plaintiff is the person who files a case, and defendant is the person who defends the case. Right? So sometimes when plaintiff files a case, he himself has done a wrong activity. And if he has done a wrong activity, he cannot claim compensation. For example, Mr. A entered somebody else's house. So entering somebody else's house is not allowed. He entered the house and the dog injured him. Can he file a case against that dog and the family? Against the family who was owning the dog? Answer is no. Why? Because he entered without permission. The first step that he did wrong was his. And therefore, there is no compensation for this. Because the plaintiff, the person who is filing the case, he himself has done a wrong activity. So he cannot get compensation. Right? So we have done the second one. We'll go to the third one now. Third point, sir, when the house owner can also not file a case against him for trespass after they have beaten him. So, Shesh, if the measures taken are proportional to the offense, then that is allowed. Okay, so beaten him can be anything, beaten to black and blue, broke his bones, etc. Or normal tie-up, so that is done. It has to be seen as per the force used. Every case will be a different case. Okay. Now, sir, it's bitten by dog. So dog bitten, yes. If it's a dog, it's allowed, completely allowed. If they have written a board outside, beware of dogs, then if there is no warning sign at the gates, then even dog bite is not allowed. You can file a case for compensation. And in London law of torts, when I talk about a house, always imagine a house which is a small house which has a garden outside, mailbox, etc. It's not an apartment, or it's not a Patna house which is all clogged. Fine. It's a house which has space in the front, space at the back, and proper house. Okay. Okay. What is inevitable accident? Fine. Definition dekhte hain. An unexpected injury which could not have been avoided in spite of a reasonable care on part of the defendant. So if the person who has taken all reasonable care possible, but still there's an unexpected injury, like the person, like for example, I send my car to the to the service center, got my car repaired, everything, and then I went on a road trip, few kilometers, and my brakes started working disproportionately. It used to brake at some time and does not at some time. And I hit someone, say Mr. A, and I injured Mr. A. Can I get compensation? Can Mr. A get compensation from me? Apply this principle and tell me. Answer is no. Why? Because first is an unexpected injury. An accident is always an unexpected injury. And second, I have taken all reasonable care possible. So once a person has taken all reasonable care possible and still there's an unexpected injury that takes place, then the person who has committed this is saved under the defense of inevitable accident. He was not aware, right? He gave the car for service center. So what more can you do with the car? What reasonable care can you do with the car? You can at most give it to the service center, right? So he has taken all care possible. Reasonable care, what a reasonable man should think. Okay. So if I have hit Mr. A, so Mr. A किससे compensation मांगेगा? मेरे से मांग नहीं सकता, तो किससे मांगेगा? Anyone? Can you guess? Service center. Wow, wow. So no service center. Why? Because the answer is no one. As per the law of torts, answer is no one. Insurance company is already always there, but as per the facts that I just stated, if insurance company had no mention, so we won't put it there. So now imagine if a car hits a person in Patna. Can you say, "Arey, मैं तो inevitable accident के अंदर हूँ, I don't hit me"? The first and the foremost thing the Patna guy will do, the guys there, they'll first take the driver out, burn the car, and then file an FIR. खूब पिटाई. Fine. So ये law of torts is good to study, but it's not practical in India. It's difficult. Fine. What have you done that? खूब पिटाई या फिर accident? Burn the car. No, I'm strictly against any kind of destroying property. And pitai as well. Accidents, yes, I have done a lot, many of them. Accidents I have done. All in Delhi. No hit and run. I have smashed a car and then I have stand properly and said कि जो भी पैसा बनता है ले लो, हो गई गलती तो पैसे ले लो, से किसने किसी इंसान को नहीं मारा है. Fine. Okay, one more defenses. It's called as act of God. And in the legal maxim terms, it's called as vis major. Fine. Act of God. So act of God क्या होता है? Act of God में incidents आते हैं, like for example tsunami, landslide, volcanic eruptions, storm, floods, anything that is a natural activity, natural calamities. Those are all called as act of God. And legal maxim term क्या है उसका? Vis major. So if anything that has happened by vis major or an act of God, then in that case there is no compensation. Fine, there is no compensation because it's an act of God. I'll give you one example. My car was parked on the road and there was a landslide and my car got destroyed. Can I claim compensation from the government? Answer is no. Other thing that we need to see under act of God, it's not that simple. That my car was parked at the corner of the road and I was clicking pictures of the entire valley. Fine. There was a boulder. You know what boulders are, which removes the large rocks on the road. There was a boulder parked on the other side of the road. Now there was a landslide and the boulder slided and pushed my car into the valley. Can I claim compensation from the government in this case? Boulder is government only. Answer is yes. This is what I'm trying to explain. Answer is yes. Why? Because had the boulder been parked properly by the government, my car wouldn't be thrown out of the road by the boulder. So in act of God, the only thing that we need to figure out is whether the act of God was a direct result or it was via some channel. Like I constructed a house, there was a lightning and the entire house was on fire. Then we can claim act of God. But if there was a faulty wiring system and then the house got on fire, then it's not act of God, it's a fault of the electrician. So all act of God examples that we see has to be direct in nature. If it's not direct, it's not act of God. Fine? Okay. So we'll stop here. And sorry, if a bike is coming from the wrong side on the highway, and then if it hits by a car, uh, it's not act of God anyway. It's not an act of God, it's a human error. On this, we have a different answer, Avishi. We'll discuss it in when we'll be discussing negligence, the last topic of torts. I have a similar example. Just remember when we start doing that. Okay. Okay. So thank you. Please fill the attendance sheet. The first one is not correct. So take the second one. Fill the attendance sheet and we'll see you soon. I think we'll see you next year now. I guess, yes. Let me check my. So this is batch of 540. Yes, we'll be seeing you next year. So wish you a very happy new year. We'll see you next year. Hope the new year brings more glory and more fun rather than this year that has gone into online classes. Hopefully we'll see you soon face to face so that we can have a good session face to face. Fine. Okay. Happy New Year, everyone. Thank you, everyone.